Good morning, friends. In continuation to my earlier videos on misunderstanding about intellectual property rights, I will cover basically three important points today. The first important point is that primarily important from patents and design patents perspective is that these two forms of intellectual property rights require a novelty feature in their respective applications before obtaining a protection for them. So what does that mean is that you should not have published, you should not have used, you should not have shown in some conferences, in trade fairs or any other exhibitions which can destroy the novelty of either your design or your utility patent. Although various national laws differ on the definition of novelty, some countries do provide grace period. For example, USA provides around 12 months time period to still file patent application even if you have displayed openly in the public. But when you are seeking global protection for your innovations, you have to have a strategy which can encompass majorly various national laws so that you do not find something fatal when you approach to a respective national patent office to seek patent protection or design protection for your innovations or inventions. The second important point today which I wish to discuss is that many times IP stakeholder consider that they are the default owner of the intellectual property rights. It is not so. If you do not have any proper agreement with your employees, with your partners, with your vendors, with your co-founders, then there is fair possibility that the other persons can claim equal rights in the uh, intellectual property rights. So two important things we must take care is that ensure that proper agreements are executed in writing before you file any IPR application, whether it is a trademark, copyright, it doesn't matter. You must be clear about who is the owner. Second important aspect from the patents is that, or the copyright is that, you must clearly identify who is the inventor in the inventions and who is the author in the copyright. Because if you do not clearly point out the exact inventor or the exact author, then you may face issues while seeking no objection certificates from such persons, or they may approach the appropriate forum for invalidating your IPR rights, because you have not listed them as inventors for patents or the authors for the copyright protection. And third important point for consideration is that we all tend to think that enforcement can only and only happen through the litigation. That's not true. We may tend to see people saying that, I will sue you in the court, but that's not exactly happen. If nothing good comes before the litigation, only then the parties choose to litigate in the court. Or even after litigation also in courts, in India, IP suits are being governed under the Commercial Courts Act, and these are the commercial cases. So in the commercial cases, one of the most important requirement before registration of suit is a pre-mediation settlement. If the parties are willing to mediate, then the court look to such a kind of settlement before even identifying the issues between the parties. So what could be the other possibilities then? If litigation is not only the source of enforcement, what could be the other? The key important alternative is licensing. Why do you want to why do you want to seek protection? Because you don't want others from using or exploiting your intellectual property rights without your permission. But if they give you some royalty, some licensing fee in return of that use, then it is a win-win situation for both the parties, for the opponent as well as for you. Another alternative is that invoking criminal jurisdiction. So the trademark or the copyright, they also enable you to seek invocation of criminal jurisdiction of the courts against the prospective infringers. Another view of enforcement is cross licensing. For example, big companies Apple and Samsung and other two competitors, they tend to cross license each other in a specific domain where they come with this where they have a common understanding that in this domain they can use each other intellectual property rights. So that's how various other forms of enforcements available for the intellectual property rights. I sincerely hope that this video and the last two videos might have cleared your misunderstanding about the intellectual property rights, and I will continue to come up with practical tips on intellectual property rights. Thank you for going through this video, and be in touch. Take care.